The HOA. For millions of us, those three letters can bring up, well, a lot of different feelings, right? From helpful guidelines to, let's be honest, some major headaches. But what happens when you're pretty sure your HOA is the one breaking the rules? We're going to dive into the true story of one homeowner who decided to take them on.
I mean, it sounds pretty intimidating, doesn't it? Just you, a single homeowner, going up against this whole organization. So what actually happens when you decide to push back and say, hey, you need to follow your own rules?
Well, that's exactly what one homeowner in Phoenix, Arizona decided to find out. Let me introduce you to Kristina Merkle. She lived in the Desert Palms Village condominiums, and she got to a point where she was convinced her condo association was not playing by the book. And you know what? She decided she wasn't going to let it slide.
Okay, so let's get into it. Section 1, the complaint. How does a dispute like this even begin? It wasn't some big, dramatic shouting match. It started, as these things often do, with paperwork.
So on December 28, 2020, Kristina Merkle filed a formal petition. And her claim was super direct. She said the association had violated its own rule book. You know, that big stack of papers called the covenants, conditions, and restrictions. We usually just call them CC&Rs.
All right, Section 2. To really get what this fight is all about, we have to talk about the rules of engagement. And the whole thing hinges on this one specific thing called a reserve study.
So what in the world is a reserve study? Honestly, the best way to think about it is like a financial checkup for the whole neighborhood. It's a report that looks at all the big, expensive stuff. We're talking the roof, the swimming pool, the pavement, and it calculates how much life they have left. Then it figures out how much money the HOA needs to be saving right now, so that when that roof needs replacing in, say, 10 years, the cash is already there. It's a huge deal for preventing those massive surprise fees we all dread.
Okay, and here's the kicker. The association's own rulebook, the CC&Rs, right, was super clear. In Section 7.13, it said they had to get a new reserve study done every 3 years. Not they should, not it would be nice, it was a requirement, a hard and fast rule they wrote themselves.
And this timeline really lays it all out, plain as day. Look at this. The last study they did was way back in 2016. The rule says every 3 years, so a new one was due in 2019. But by the time this thing actually got to a hearing in 2021, well, you can do the math. 5 years had gone by. That 3-year rule wasn't just bent, it was completely broken.
So where does this all lead? To a showdown. Section 3, the hearing. On March 25, 2021, it was time for both sides to make their case in front of an administrative law judge.
When you boil it down, the arguments were actually pretty simple. On one side, you have the homeowner, Kristina Merkle, and her claim was just a fact. The rule says every 3 years, and it's been 5. Simple as that. Now, the association, they didn't even try to deny it. Their defense was basically, well, we've been making repairs anyway, and getting a whole new study just didn't seem cost-effective. So they were kind of saying they followed the spirit of the rule, even if they ignored the actual words.
Okay, so both sides have made their case. Now what? It's all up to the judge. Let's get to Section 4, the verdict, which was handed down on April 14, 2021.
Now, before I tell you what the judge decided, there's a quick legal thing to understand. This wasn't a TV crime drama where you need proof beyond a reasonable doubt. The standard here is called preponderance of the evidence. That's just a fancy way of saying what's more likely to be true. All Kristina Merkle had to do was convince the judge that her side of the story was just a little more probable than the HOA's.
And she did it. The judge sided with her. The first big part of the decision was a clear win. The judge looked at the evidence and said, yep, the association absolutely violated its own rule, Section 7.13. No question about it. Next up, the money. The judge ordered the association to pay Kristina $500. Now, why that amount? Well, it cost her $1,000 just to file the case, so the judge made the HOA pay for half of that filing fee. Pretty fair. But honestly, this next part might be the most important piece of the whole puzzle. The judge issued a final order telling the association that, from now on, it had to follow its own rules. So this wasn't just about punishing a past mistake. It was about making sure they do the right thing in the future. Now, it's important to note that this wasn't a clean sweep. Kristina actually had a second complaint, claiming the HOA failed to give her some documents she'd asked for. But on that specific point, the judge said she hadn't provided enough evidence, so that part of her case was denied.
It just goes to show, these things aren't always all or nothing.
Okay, so let's zoom out. Section 5. Why does this one case in Arizona matter to you or to anyone else living in an HOA? What's the big takeaway here?
I think the takeaway is actually pretty powerful. This case proves that a single homeowner can, in fact, hold their association accountable. It shows that those giant CC&R books aren't just filled with suggestions. They are binding rules, and there's a system in place that allows one person to make sure the organization plays by them.
So, what Kristina Merkle did here basically gives us a playbook for how to do this. There are 3 key lessons. Number 1, you got to know your rules. You have to actually read your CC&Rs. Number 2, document everything. A formal petition is what gets things done, not just a bunch of angry emails. And third, use the official system. These state hearing processes exist for a reason. Use them.
And really, that brings us right back to you. This whole thing happened because one person knew one specific rule and had the guts to demand that it be followed. So it kind of leaves us all with a pretty important question to think about. Do you really know what your HOA is responsible for?